Your union contract must give a grievance procedure including a provision for compulsory binding arbitration. This grievance procedure must also be available for all written disciplinary actions. In the event that the parties cannot agree on a grievance procedure that includes binding arbitration, the parties will be subject to the grievance procedure developed by the BMS. Let's take a look at the basics of a grievance procedure in your union contract. A grievance occurs during contract administration and refers to a dispute over an interpretation or application of a provision of a labor agreement. Simply, a grievance is a dispute or disagreement as to the interpretation or application of the specific terms or conditions of a specific labor agreement. Grievance procedures can vary depending on contract language, therefore, it's always important to have the most up-to-date agreement as a reference. Grievance procedures, depending upon how they're drafted, most often deal with two primary areas. Number one, disputes or disagreements about whether an agency violated the union contract that involves contract interpretation, or two, whether the employer violated the union contract when it disciplined an employee that involves both the application of fact and a discipline standard. The first type of grievance is commonly referred to as a union contract language or language type of grievance. Again, depending upon the language in the union contract, this type of grievance can involve the interpretation of actual contract terms and may be broad enough to include grievances under past practice claims. The second type of grievance is commonly referred to as a discipline grievance. This type of grievance will be over whether the agency violated the disciplinary language of the union contract or any associated procedural rights. After the probationary period, disciplinary action is subject to the grievance procedure and compulsory binding arbitration. Some union employees are also covered by a civil service system with its own grievance procedure. In these situations, the employee may utilize either procedure but not both. Typical contract provisions limit a grievance to a dispute or disagreement regarding a specific contract provision. Language allowing the grievance procedure to be used for any employment dispute is too broad in that it allows grievances based on personnel policies, employment laws, and other areas not addressed by the body of the contract itself. An important provision of your grievance procedure includes how many different levels the grievance should be presented and considered. These different levels are commonly called steps. The number of steps is primarily determined by the size of your agency. Since the supervisor is the initial management person with the best knowledge of the facts, that supervisor is the logical first step of your grievance process. This helps an agency define that position. Arbitration is always the required last step. The final decision-making authority, such as a city manager or a city council or board, is usually the last step prior to arbitration. Other steps in the process should be added or substituted based on the size and organizational structure of your agency. It is an unfair labor practice to fail to comply with a grievance procedure. It is important that timelines are established at the first step from the beginning triggering event to the balance of the grievance process. From the employer's perspective, having a defined time for addressing a grievance allows the agency to rely on the finality of decisions that have occurred in the past. In dealing with disputes, it's also important to require those disputes be raised and identified when all of the parties to an incident still are able to have a recent recollection of the occurrence. Without a timeline, for an example, a union could allege an agency violated a contract provision related to holidays beginning 5 years ago and seek to have the same violation apply to each subsequent holiday that occurred. Under Minnesota Data Practices Statute, certain personnel data are classified as public, including discharge and disciplinary actions. The final disposition of any disciplinary action, together with the specific reasons for the action and the data documenting the basis for that action, are public, excluding data that would identify confidential sources who are also agency employees. Final disposition occurs at the conclusion of the arbitration procedure or upon the failure of the employee to elect arbitration within the time provided by the collective bargaining agreement. Until that final disposition is reached, the discipline and all data supporting that discipline remain private. In creating a timeline, the employer and union will need to negotiate language into the contract defining how time will be computed. This typically involves a discussion about whether calendar or working days should be used and what should be done in the event the deadline occurs on a weekend or holiday. In the event calendar days are used, the parties may discuss what occurs when the final day falls on a Saturday, Sunday, or holiday. In that instance, a typical contract provision allows the next regular working day to be the deadline for filling the grievance. In instances such as law enforcement, where there's no typical Monday through Friday work week, the use of calendar days is preferable. It is important for the employer to negotiate language into the contract that clearly defines what the triggering event is that starts the clock for a timeline in the grievance procedure. The optimal language is to have the time start upon the first occurrence of the event constituting the alleged violation. In contrast, the union will typically seek to include language that the event should not be considered until the employee knew or should have reasonably known of the occurrence of the event constituting the alleged violation. It is also important for agencies to recognize that some events will be viewed by arbitrators as continuing violations. This applies where an agency is repeatedly or continuously violating the contract. An example of this is where an agency has applied overtime calculations throughout a number of payroll cycles. In a continuing violation, a grievance will not be viewed as untimely. An agency's failure to respond at any step within the time provided should be treated as a denial, and the union should be permitted to appeal to the next step. It's all about grievance response. A negotiated grievance procedure should never indicate that an employer's failure to answer on a timely basis will result in the grievance being resolved on the basis of the union's last statement of the grievance. The latter is what's included in the BMS default grievance procedure and why employers should avoid that default procedure. Another key provision in any negotiated contract should be the union's failure to meet timelines noted in the agreement will result in a waiver of the grievance. Strong waiver language, where there is no dispute a union missed the timelines, may allow an agency to refuse to process a grievance. In such an instance, the union will be forced to decide whether it wishes to attempt to go to district court on a motion to compel arbitration. In that setting, the union and the agency will attempt to convince a judge the grievance should or should not proceed to arbitration. It is also typical for the parties to include language allowing the parties to mutually agree to extend or waive the timelines in certain instances. This is common where the parties have difficulty scheduling a grievance meeting or the agency needs additional time to research a grievance. In such an instance, best practice is to require such an extension in writing. In the event that such language, as we've discussed through this presentation, is not included in a union contract, or the parties operate under an informal system where timelines are commonly violated, the agency may be prevented from later seeking to hold the union to a timely grievance under a theory that the employer has waived the right to strictly enforce timelines. Particularly within a larger organization, adherence to timelines is a key factor in grievance management.